Audrey, yeah, just so everybody knows, we're recording this, and we will decide if it's going to be posted or how we're gonna disseminate after, and that's for the people who weren't able to attend. Audrey, do you want to go ahead and kick us off?
I would love to. Good afternoon, everyone. It's such a treat to see you. My name is Audrey Ruffet. I am the Executive Director of Integrity Matters. We're a group of small business owners organizing to protect the rules of free enterprise, the rule of law in America, addressing the challenges that we're seeing today. I'm here today with my colleagues, Kip, Maya, Rosie, and we are talking about Schedule PC. You are going to hear from an expert. I'm going to introduce our esteemed guest, Jules Torti. And I want you to know that you can ask questions in the chat if you like. We are going to have the following format. Jules is going to share important details about what schedules PC is going to look like. I know that for folks here on this call today, you yourself have clients who are federal contractors, so having this information accurate is going to be really important to you. So, I want to make sure that she shares that information, and then we're going to take questions afterwards. So that part will run about 30 minutes, and then we will jump into questions. So that's a little bit about Integrity Matters, about the format of today's event. And I'm thrilled to introduce Jules Torti, who is counsel at Protect Democracy. And her work focuses on slowing the erosion of the rule of law. Jules was an attorney at the United States Department of Justice, um, and Jules litigates cases defending government institutions and personnel from attack and really focuses to strengthen the guardrails against these abuses. So let's talk a little bit about what we're going to talk about today. Okay. This is the focus is about a hidden way that an anticipated, again, not yet in place, an anticipated new government regulation, schedule policy career uh, could really dramatically expand the number of government employees who are covered under the Lobbying Disclosure Act. So I'm excited to hear why this is happening, what small businesses should expect, and really what we can do to prepare for this. So, Jules, take it away.
I am happy to. Thank you, Audrey, and all the folks at Integrity Matters for putting this together. Um, Things are about to get real wonky, folks. Let's see. I am properly sharing my screen. So, I'm going to speak with you today, like Audrey said, about a really quiet shift. And if you'll bear with me while I make sure I have my files in order. Ta-da. So, this is a pretty small group. I cannot see the chat because of how my computer is set up, but if you have questions, go ahead and put them in the chat, and perhaps someone from Integrity Matters can unmute and shout them out as we go through. So I do have a PowerPoint, and then we'll have plenty of time for questions, both at the end and as I'm going, if things don't make sense. So it has been a busy time, or it has been a busy year for folks who work on the civil service. As folks know, there's been a lot of changes, and one of those many changes is called Schedule Policy Career. So I'm going to be going through that policy and how it intersects with the LDA, the Lobbying Disclosure Act. What I'm not going to be doing is giving legal advice. You may decide to seek some after this presentation. So this is meant to be educational to help you decide, like, do I need to talk to a lawyer about this? Does this apply to me in my business? So I'll put the conclusion right up front. Schedule Policy Career, which is a new anticipated regulation, is likely to interact with the Lobbying Disclosure Act in a way that could increase burdens on businesses. So to get there, to get to that conclusion, I'm going to give y'all a little bit of a primer on the civil service and Schedule Policy Career specifically. Then I'm going to go through a primer on the Lobbying Disclosure Act, just like a real basic, what is this and what are the requirements? Talk about what the change is and why it's happening. And then talk a little bit like brass tacks, like what are the risks of complying or not complying with this new regime, and how might businesses like yours navigate the change. So with that, I'll jump in on our background. Um, for the past 100 or so years, the government has operated in a system where most civil servants have tenure, essentially tenure. We usually call it for-cause removal protections, but the upshot is they're not at will like most private employees, like most of your employees probably are. And this is not really because Congress wanted to protect civil servants themselves. It's to protect the political independence and expert decision making of those civil servants. So there are reasons why a civil servant can and cannot be fired. And on the no-no list is things like you're in a different political party or you voiced an unpopular opinion. And that is meant to protect the integrity of the programs and services and the government that provides them. Congress didn't do this out of the blue. We used to work under a different system where people could be fired for stuff like that, and the results were not great. So these tenure protections are a pretty big part of the fix, and they've served the government, I think, fairly well for the past 100 years or so. There has always been a narrow exception for political appointees. They can be fired for no reason. They do not have tenure. And this is because Congress has always recognized the president will need some folks to help implement his or her own agenda. There are about 4,000 of these right now in, well, the United States. There have historically, in modern times, until this administration, been about 4,000 of these positions, which is actually like fairly high for Western democracy from just from a comparative perspective. All federal employees are broken down into different categories called schedules. So when you hear schedule, it just means category. And all of the political appointees are in one category called Schedule C. But we're not talking about Schedule C, we're talking about schedule policy career. And so what is schedule policy career? It's a new category that is about to be set up of a federal employee. It doesn't exist yet technically, but this administration has put out an executive order, many memos, and a proposed regulation aimed at creating it. If you remember Schedule F from Trump 1.0, this is the same thing, just rebranded, updated a little bit, tweaked, but effectively the same thing. So schedule policy career employees won't technically be political appointees, but they also won't have tenure protections, which is not the way the law was supposed to work. The plan is to create this new category, this new schedule, and then involuntarily move a bunch of federal positions into it so those employees lose their tenure protections. How did the administration create this category? They expanded the definition, or in my opinion, misinterpreted the definition of this specific phrase, which I'll call the magic phrase throughout this presentation, but it is confidential, policy determining, policy making, or policy advocating positions. That used to just refer to political appointees, but now they're saying, no, it applies to this much broader swath of federal employee who is kind of high level and it kind of has something to do with policy making, as far as we can tell. So we're going to hold that information in our heads and do a pretty hard pivot now to talk about the Lobbying Disclosure Act. Remember, this is about how two kind of laws or regulations interact with each other. So we looked at one, we're going to look at two, and then we're going to bring it all together. The basics of the Lobbying Disclosure Act are that Congress thought lobbying was a problem, but didn't want to stop lobbying altogether. So they passed the Lobbying Disclosure Act to bring transparency so people could see the businesses, the people, the nonprofit having influence on laws and regulations. One question that comes up a lot, and it came up a lot in some of the questions y'all helpfully sent in before the presentation, is whether businesses and nonprofits are treated differently at all, and whether the LDA applies to nonprofits. The answer is they are treated exactly the same. So when you see the word business in this presentation, sub in business or nonprofit. And I apologize for not making that clear in the slides, but there's absolutely no difference between a nonprofit and a business, or I say no general difference, no difference for the purposes of what we're talking about with regard to the LDA. The way the LDA accomplishes that transparency goal is by registration and reporting. That's what it does. It's a registration and reporting statute. So, generally speaking, businesses have to register when all three of the criteria on this slide are met. The business has at least one employee who makes more than one lobbying contact on behalf of the business. That employee will spend at least 20% of their time doing that. And the business will spend more than $16,000 lobbying in a calendar quarter. So, okay, it's a lot of technical language. What is a lobbying contact? That's kind of the main part. There's basically two parts: lobbying contacts with certain people. So a lobbying contact actually has a pretty broad definition. Any communication with a certain individual, a covered executive or legislative branch official regarding certain topics. Some of those are obvious: legislation, regulation, executive orders, things that you think of when you think of lobbying, but some are less obvious. You see the administration here. I'll make this part bigger. The administration or execution of a federal program or policy, including talking about contracts, grants, loans, permits, or licenses. And so that is, I think, activity that a lot of nonprofits and businesses engage in. Don't fret quite yet. There's an exception. There are a few exceptions. Some of them are on this slide, not all of them. But generally speaking, contacts that are really administrative in nature, like setting up a meeting, don't count. Contacts that are just answering a federal employee's question, like giving them information they request, doesn't count. And a communication you are legally required to make, sending in your tax returns, for example, answering a subpoena, those don't count. There are other exceptions too. I would, if you're kind of concerned, you may qualify under the LDA. I'd take a good look at those. So we've kind of covered lobbying contacts, right? We know it's a communication with certain people about certain topics. Which people? So I'm going to focus on the executive branch officials because that's where the change is. So what is a covered executive branch official? Most of these are pretty obvious. There's 6 categories per the law. President, okay, that's pretty obvious. Certain military officials, certain high-ranking military officials, also pretty obvious. But what is this category down here? Also, the LDA says a covered executive branch official is an officer or employee serving in a position, and then it recites our magic phrase. So if you remember from earlier that same magic phrase, you have officially noticed the issue. And Audrey, I see your hand up.
I am going to flag a question for you from the chat.
Thank you.
Uh, Tanya asks whether reporting on an existing grant or answering questions about an existing grant would count as a contact, a covered contact under the LDA.
So that is a very good question, and I'm not going to have a clear answer for you, but I can help you figure out how to answer it, right? So the first question that you're going to ask is this person I'm communicating with a scheduled policy career employee? If they are not, stop. Like, it's fine under the LDA, under this analysis. If they are, we're going to ask a few more questions. And I have a slide on that coming up, so I'm going to save the answer for that. But that's going to be your first question. The answer is going to be maybe, just to preview. So you may have noticed the issue. The magic phrases used to mean these 4,000 political appointees who were pretty easy to identify. The administration now says that those same words, the magic phrase, confidential, policy determining, etc., means something different. It means about 50,000. They've estimated 50,000 employees will be moved into scheduled policy career. And some of these, they have not said, to be clear, what the positions will be. there will be an executive order that will have a list of these positions, or will announce the positions in some way. But Protect Democracy has issued FOIA requests to agencies to ask them what positions they are recommending to the administration be put in schedule policy career. And on this slide are a collection of some of the positions that they have sent back. Um, these are pretty low-level positions, in my opinion. That's my read. Having worked in government and knowing folks at the GS8 or GS9 level, I see like a program support assistant here. I see a paralegal here. That in my old office would have been a pretty junior paralegal, not even a senior paralegal at a GS9 level. Um, so I think the takeaway from this is you might not know from looking at them if they're considered a schedule policy career employee, and that introduces, confusion and risk. Um, so that was the wonky deep dive I warned you about. But this is the bottom line. Many more contacts with the federal government, many more federal employees may qualify as contacts under the LDA. So if you are already registered, this may mean you have more contacts to report. And if you are not registered, if you've never registered under the LDA, you may want to. You may determine that you need to. Um, so before we jump into like kind of how to analyze that, I want to talk about what the risks are of non-compliance, like what the penalties are for not being seen as complying with this law. So in ordinary times, like the normal regime, the law says that you can be subject to a civil fine of up to $200,000. That is true. In reality, most of the time these cases are settled, and it's less than $200,000. That is the upper limit. Um, Also, and I should stress here, there are people who are very much experts in the LDA. I have not that depth of expertise, but I do believe that most of the time people get notices of like defective filings and then are given a chance to correct them. So ordinary times it's mostly civil penalties. There is technically a criminal penalty under the LDA that is not unsevere, up to 5 years in prison. This is so rare. I need to emphasize that. The first one of these prosecutions ever was in 2020, and I'm not sure that there's been more than one. There may have been, but they are very, very rare. Um, and usually reserved for like incredibly unique circumstances. So I want to pause here and just acknowledge it is really reasonable and even very smart to take a breath and ask, like, seriously, like, is the government really going to go after my small business for not reporting contacts with these relatively low-level employees, especially when there's like this change in the law that is actually that's pretty hidden, is pretty quiet. And to be clear, I think that is an open question. I think nobody really knows the answer of where the government is going to pursue enforcement actions or not. And I also want to acknowledge that guidance that the government itself has put out previously about the Lobbying Disclosure Act has said this is really about political appointees. Now, that was before schedule policy career, but they've said that in the past. And in ordinary times, I think that line of thinking would be really wise. I think the government probably would not go after businesses for not complying with a shift like this without providing like a ton of notice. I also think that we're not operating in ordinary times. So I just want to like bring us to reality a little bit, right? On this slide is a picture from Mischief Toys in Minneapolis, Minnesota. The owner said, like in an article, that they had been handing out whistles. Whistles have often been used, as folks probably know, to alert neighbors to ICE's presence in Minneapolis and other cities. And the owner of Mischief Toys, which is like a small mom and pop toy store, reported that soon after the article was published, an ICE officer showed up at their doorstep with notice of an audit demanding all sorts of employment records, financial records, tax returns, etc. So even if like Misfit Toys has their books in order, this sort of thing is scary and burdensome, like being investigated by the government. Imposes a ton of burdens. Trust me, I have investigated businesses on behalf of the government. It's a pretty onerous process. And so in extraordinary times, these are also the sorts of risks that unfortunately we have to think about. I think of enforcement authorities like tools, like a crowbar in the hands of like a handyman is a good thing. A crowbar in the hands of a burglar is a bad thing. An enforcement authority in the hands of a responsible government can be great. An enforcement authority in the hands of a government who weaponizes that authority can be really harmful. And so that is how I encourage thinking about something like the LDA in these times. And yes, Audrey and Kip, I see both of your hands.
I was just going to flag a question that we have from Frank. And the question is, by the way, folks, we're going to do question and answer after this, but I think these are good clarifying questions. Are employees in the offices of members of Congress covered under the LDA?
That is a great question and is beyond the scope of something I can speak authoritatively on. So, because this shift, like the change, implicates the executive branch employees, my understanding is that whatever the rules were before about legislative branch, about congressional employees are the same. I'm just like not a good enough expert on that to speak authoritatively, so I apologize there. Lawyers, man, we can, we're not going to say something unless we're totally sure. I apologize for my profession.
But when we talk about Schedule PC and the schedule of federal employees, we're mostly talking about executive branch employees. Is that fair to say?
Yes, that is very fair to say. That's exactly right.
Okay.
Any more questions? I'm gonna cruise on. We're getting next to how businesses can navigate the change.
Yeah, go ahead and forge ahead.
All right. All right. So, Tanya, I think this is a little bit what you were talking about before, or maybe will help provide a bit of a framework. So, in thinking about how I would maybe navigate this from a business's point of view, I think there's some basic questions to ask. So this is if your business or a nonprofit currently is not registered, but is now concerned that you might need to. Um, so looking at that really broad category of communication, like the type of communication, do you speak to federal employees about a grant, a loan, things like that? And if so, is that the sort of thing that might fall into one of those exceptions, or might those really be communications under the LDA? And if that's true, think about who you're talking to. Are any of those federal employees in schedule policy career? You can just ask, is the magic thing. You can just ask and they'll tell you. And if they don't tell you, you can ask to speak to you can escalate that. I would do that in writing. I would get a clear yay or nay in writing. And remember that they don't know yet. Even the civil servants who frankly are put in a terrible position here, many of them live in fear that they will be put in scheduled policy career and lose their job protections and not be able to speak freely to the extent they were speaking freely right now. But just asking, getting clarity is a really low lift way to clarify. And if the answer to both of those questions is yes, if yes, you're having the types of communications that can qualify under the LDA and you're talking to a person who is a covered contact under the LDA, it's worth running through those other questions. Will an employee be spending more than 20% of their time on this in a quarter? And have we met the monetary thresholds? And for that, that's where I start to recommend getting some real legal advice, like specific to your business from someone with expertise in the LDA. And those people exist. And then, so thinking about kind of going a step further, if you decide you do need to register, or you might just need to report more. I think it's reasonable to take that breath, take that step like we talked about, decide how you're going to balance that risk. Like if you would be subject to a really onerous new tracking and reporting requirement, I think it's worth thinking about whether you want to be conservative and tracking everything and reporting everything, or whether you don't have the capacity to do that. If you do, if this is the normal kind of compliance work that you would usually do, identify the key employees who have the contacts, identify the key employees whose responsibility it is to ensure compliance, and then additional training. And so this is the last slide. I'll kind of end here, but I did want to put up a few different types of businesses that might have different responses to how to weigh risk. And so, a business like Business C, who has a customer base and employees who really value being able to speak frankly on issues of public importance, might choose to take a conservative approach here and minimize their risk of a federal enforcement action. If you're business B and you're a super small business and you're not doing well financially already, and the increased compliance costs are something you cannot bear, that might put you in a different position about whether you feel like you can speak freely, criticize public policy, etc. And that is unfortunate, but I want to acknowledge that like different businesses are going to make different decisions in different contexts. You may also be business B and decide it's worth it anyway, and those are like personal decisions for people and humans and businesses to make in this really odd time. But I will end there with an acknowledgement that everyone brings kind of different background to this decision, and there's no straightforward way that everyone is going to respond. So with that, I will open up for additional questions or conversation.
Thank you so much for that, Jules. I know you kicked us off by saying this was going to be wonky, but I thought that was compelling and very clear, and also a little intimidating that this is coming down the pike. So I want to start us off with one question as folks are thinking of theirs, and we'll certainly be including the ones that you've sent by email in advance. But in terms of implementation and timing and notice that businesses will have for this shift, what can you tell us?
So, in terms of knowing when scheduled PC is created and when folks are moved in, though that will be the rule will be published on the Federal Register, which is a pretty unsatisfying answer because who tracks the Federal Register? But technically, the rule will be made public. I know at Protect Democracy, we will put out a newsletter on that. If you don't subscribe to our If You Can Keep It newsletter, this didn't mean to be a plug, but it's turning into a plug. We have a newsletter called If You Can Keep It, and a specific kind of subset of that called Dear Civil Servant, where we write about civil service issues. We will certainly be publicizing when the rule finally comes out. And that would be, if you're a business, your trigger point to start asking those contacts that you have in the federal government, hey, did you get reclassified? Did you get moved into this new category? If you do, I need to know that. I think that's the first step.
Thank you. I'm going to pause and see if there are other questions before I come into the ones that came by email.
Go to my question slide.
So I'm going to toss one out that we got by email, and I think just for the level of specificity, it'd be great to get your take about the steps, if they're any different from what you've recommended, the steps that federal-facing small businesses, especially 8A firms and subcontractors, should prioritize for operational resilience.
So, I mean, I think my step one would be identifying where you have contact with the federal government, and step two is once schedule policy career is officially enacted, ask all of those people. I think then you'll have a lot of information you need to start deciding whether you need to ask further questions. If you interact with a lot of folks who are in scheduled policy career, I might do a little bit more digging, thinking about the types of communications you're having. If you don't, then you know, okay, this is maybe not something that really applies to me, and you can move on.
That's great.
Today, we're going to reframe a common thought.
Oh, sorry about that. Kip, I saw you unmuted yourself. I didn't want to step over you if you have questions.
No, I don't have any questions. We just had Pamela join us, so welcome, Pamela. We've just entered the question and answer phase. We did get some questions in advance about nonprofits, and you mentioned that businesses and nonprofits are the same as far as this is concerned. But one of the questions was, is there a de minimis threshold for registration under the LDA, especially if you're a nonprofit? But I think that goes for businesses too.
Yeah, absolutely. The LDA thankfully is not meant to capture like de minimis activity. You do need to spend $16,000 a quarter, which for small businesses relieves some of the burden. An employee also needs to be spending 20% or more of his or her time in a quarter to be kind of swept up under the scope of the LDA. So there is a de minimis kind of exception by nature. I'll also say if you are a nonprofit, there is a lot of guidance aimed at nonprofits, like from other nonprofits. And so you might be able to find a little bit of kind of education resources online. And additionally, some of the orgs might provide a little bit of like training or consultation. So if you're a nonprofit, I might look out into that world and see if there are resources aimed specifically at you, and also that acknowledge kind of the limited funds nonprofits might have for this sort of work. And Tanya, I see you're a CPA and you're asking what types of expenses would be included in the 16K. This is where you're going to need to unfortunately talk to an attorney with real expertise on the LDA. What I will say is that if more if more interactions or communications count as lobbying contacts under the LDA, then the expenses associated with those contacts will generally be included in that 16,000 number. So it's not like you can look at the 16,000 as a freestanding requirement. If the number of communications that count, like if the reporting requirement balloons, it can also balloon that number as well. So I would just make sure that you're thinking of those two things as related. Um, yes. Let me know if that doesn't answer your question all the way. And then Maya, I see you've asked, what were the intentions of creating these requirements? Maya, do you mean with regard to in the LDA? What was the intention of the LDA or the intention of the shift for schedule policy career?
I mean, a little bit of both. What do they hope to accomplish by doing this? Like,
Mm. With regard to the LDA, I think the initial aim of the LDA was to make sure businesses have to report, i.e., bring transparency to contacts with high-level federal officials that could affect the policy or decisions, high-level decisions of the federal government. What this administration has done in creating schedule policy career is saying, actually, a lot more people, in our opinion, a lot more people than you have thought for the past many, many years, are high-level government employees. They're saying this really intersects with this deep state theory. They're saying that there's a lot of people who we think of as ordinary civil servants within the federal government who really are pulling the puppet strings behind the scene and controlling the actions of the federal government. And this was a big theme that we saw emerge at the end of Trump 1 and after Trump left office the first time, that he had really been stymied by the deep state, that he had wanted to do bigger things, but there were all of these kind of government bureaucrats who got in his way. So this is a way that the administration is trying to say, no, those people are actually pretty high level and they affect policy. And because they affect policy, I, the president, can have control over them. They're high enough level that they are my people to directly hire and fire as I wish, just like political appointees. And so what's the point? The point is additional control. The point is additional control, both in terms of being able to fire people who do and say things that you don't agree with, and being able to control people through the threat of being fired, right? And so if I'm a civil servant and I think, well, I have a really different opinion. I think that, this course of action is really risky. But I think if I say that I'm going to be fired, then I'm not going to speak up. And so there's less internal resistance from within the government, which is something that Trump has really publicly decried, was all the internal resistance from his first administration. To be clear, I think this narrative is not accurate in a lot of ways, but I think that is where it's coming from. It does, unfortunately, bump up against an actual law that says, my reading, I think the correct reading of the law, everybody who's not a political appointee needs to have tenure protection because that's how we ensure the independence of the federal civil service. So I do not think this is legal, but it is happening. I will say, I should have said stop. Protect Democracy has sued to stop this, and is, vigorously pursuing that lawsuit and ready to roll as soon as the rule comes out. But you know, new regulations create risks, and we acknowledge that, even if we hope that our lawsuits stop them.
Thank you for giving us that kind of overarching view of what the rationale might be and the implications for both businesses and democracy, what that looks like. Uh, let's make sure that folks know. Thank you so much, Tanya, for your question about the newsletter. So, Jules, do you want to speak a little bit to how folks can get more information?
Absolutely. So Tanya very helpfully put in the chat the link to our newsletter, called Dear Civil Servant. I will say that I wrote this with colleagues very frequently in the first 6 months of the administration, when the attacks on the civil service were so fast and so numerous that they were hard to keep track of. And, in my opinion, traditional media was not maybe ready for how quickly things were going to change. It was very much everything, everywhere, all at once, as we can all remember, and specifically about the civil service, which is like not something we all kind of talk about and report on all the time. We write less frequently now, but still use the newsletter to push out what we think are important developments to folks who care about the civil service. Both civil servants themselves read it, and just folks who care about civil service independence and believe in the idea that the civil service can, again, serve as a bulwark against executive excesses, as it was intended to do.
I
Tanya,
have
you
a,
can keep on repping the newsletter wherever you go. You'll get no problem with that.
do we have any other questions from our audience? I do have a question if nobody else has an immediate one. And that is, like, since we're here talking about democracy and new regulations being passed or put upon us, I mean, I know that the public comment period has already ended on this, but what pushback or what discussion do you see being injected into this situation? And do you think that there's a likelihood that maybe that number, 50,000 employees, might go down? It might be more reasonable. I mean, one of the real risks to some of the people who are in our network might be that if you, let's say you have a federal grant, right? Let's say you have a business that receives federal funding to try something out to see if that might help bring manufacturing back to America, for example, and you talk to the contracting officer's representative. If that person's a scheduled PC employee, then you're going to have to register that. And that's just not really reasonable because you're going to be talking to that person probably every week. So what are the chances that some of the most onerous aspects of this regulation will be pulled back?
So you identified exactly the right spot, Kip. So I think that the gears are turning, the ball is rolling on the regulation itself. They've proposed a regulation, and I see no indication that they're not going to follow through with issuing it. But this question of who is moved, like who falls in this category, is very much an open question. And I think advocacy around that stands a chance of being effective. So if businesses said, hey, hold up, like look at the Lobbying Disclosure Act. It uses the same definition of these magic phrases as the civil service law that you're trying to fiddle with. And so this really impacts us. You need to make sure my elected representative needs to, help make sure or advocate for, or I need to advocate directly for this being a really narrow expansion. It's going to be an expansion. Whether it is a really, really broad one or a much more narrow one may be in the hands of advocates. I say may because I think maybe a fool's errand to predict when advocacy is effective or not, but there's nothing to do but try.
Right. If there aren't other questions, I think this is a great place to pause and know that you can come back to us with questions and we can send them on to Jules. You've got a resource in Dear Civil Servant. And we're just so glad that you're here today to understand what the implications are of Schedule PC, bring them back to your clients, know that in your own work, this is coming and that there's a lot of work to be done. So I want to thank you, Jules, for being here to share your expertise and insights into this, and know that it's very much appreciated by us and the small business community. And I want to thank you all for being here. So, Jules, would you like to give us the last word today?
I think the last word will be that, there's been a lot of criticism of businesses not standing up for democracy at this critical moment. And just knowing that this group exists and that folks have signed on to hear about a change like this is heartwarming and encouraging. And I'm just so glad for the work that you all are doing, both at Integrity Matters and the folks who are plugging in and bringing the message back to their own communities. So thank you all for the work that you're doing. The business community is a critical part of the advocacy community. And if we want to see change, I think you'll have to be part of that. So thank you.
Thank you, Jules. Let's note here in the chat, Tanya's got another great question, talking points to share with other individuals to make sure that your voice is heard. And Maya has shared in the chat our toolkit on Schedule PC. So, and other additional responses as well. So thanks so much, everyone. I hope you have a great rest of your Friday.